Good morning. This is your Kelso Report for January 7th, and I'm your host, Clark Kelso. Happy New Year, and hope you all had a good break. We begin this year with the Ninth Circuit affirming the conviction of a real estate development company's CEO for criminal violations of the Clean Air Act. A decision imposing a heightened pleading requirement for certain claims brought under Section 11 of the Securities Act of 1933, and a California Supreme Court decision extending the doctrine of primary assumption of risk to the bumper car rides at amusement parks. But we began the year with an unusual criminal prosecution for a violation of the Clean Air Act. In United States v. Yee, the Ninth Circuit affirmed the conviction and sentence of the chief executive officer of a real estate development company that contracted to have condominium ceilings scraped and refinished without proper asbestos disposal or notice to the workers doing the scraping and refinishing. The primary issue on appeal was whether the facts supported the trial court's decision to give the jury a deliberate indifference instruction. The instruction advised the jury that they could find the defendant acted knowingly if the defendant was aware of a high probability that there was asbestos in the ceilings and deliberately avoided learning the truth. The Ninth Circuit held that the facts supported the instruction. In particular, the evidence was that the defendant had actually commented on the likelihood of asbestos in the ceilings during his initial walkthrough before his purchase of the property. His own testimony was that a person as experienced as he was in the business would be aware of the likelihood of such risks in older buildings, and an environmental due diligence report before the purchase actually found asbestos in the ceiling. The defendant's main argument was that there was no evidence he deliberately avoided learning the truth because he relied on subordinates to read reports and make sure everything was properly handled. He never knew the environmental due diligence report said there was asbestos. Well, the Ninth Circuit rejected this argument, holding the jury could quite properly reject his explanation that he was just too busy to read reports, and the jury could infer from the evidence that he deliberately avoided learning the truth about the presence of asbestos. The decision is, among other things, clearly another wake-up call for CEOs everywhere that the job comes with real accountability when things go wrong. You can't hide behind your subordinates and simply say, "I didn't know." Well, our next case involves the securities laws. Now, several years ago, in its decisions in Bell Atlantic Corporation versus Twombly and Ashcroft versus Iqbal, the United States Supreme Court took a step back from pure notice pleading, holding that, in addition to providing fair notice, a complaint's allegations must suggest that the claim has at least a plausible chance of success. As explained in Iqbal, the complaint must allege, quote, factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged, close quote. The Ninth Circuit applied this new pleading requirement in re Century Aluminum, which involved allegations under Section 11 of the Securities Act of 1933 that the defendants had issued securities under materially false or misleading registration statements. The problem in the case was that the company had issued securities under two different registration statements. It had an initial offering of about $50 million and then a subsequent offering. And under Section 11, the plaintiff needed to be able to prove that the stocks it purchased had been issued pursuant to the second registration statement, which is the statement that allegedly had the misleading statements. Now, it's actually very difficult to prove which registration statement a market share of stock came from, because shares of stock in the open market do not show their lineage. Only if the plaintiffs had actually purchased shares as part of the issuance would they have a clear path forward. And the plaintiffs conceded they purchased on the open market. So the issue was whether the complaint was sufficient, given that it pled, without any factual support whatsoever, that the shares they purchased had been issued under the second registration statement. Well, that general pleading was not good enough for the Ninth Circuit. As the panel noted, because of the 49 or 50 million shares in the market at the time of the secondary offering, and there was nothing in the complaint that would permit an inference to be drawn that the shares purchased by the plaintiffs were traceable to the secondary offering as opposed to the first offering. So, with the complaint being insufficient, the court affirmed a dismissal. Our last case is from the California Supreme Court involving the doctrine of primary assumption of risk. Now, some 20 years ago, in Knight v. Jewett, the California Supreme Court rationalized what had become a real tension in California law between the doctrine of assumption of risk and the doctrine of comparative fault. The problem is that assumption of risk is an all-or-nothing defense that is triggered when the plaintiff exposes himself or herself voluntarily to certain risks. And comparative fault is a limited defense that simply reduces the plaintiff's recovery when the plaintiff's own unreasonable conduct has contributed to the accident. The two defenses appear to have a significant degree of overlap. In Knight, the court rejected an argument that comparative fault had entirely replaced assumption of risk. But the court appeared to limit assumption of risk to only certain types of risks in sporting activities. Knight itself involved an injury that occurred during an informal game of touch football. The issue before the Supreme Court last week in Nalwa v. Cedar Fair was whether primary assumption of risk applied to a plaintiff who suffered a fractured wrist which resulted from a head-on collision in a bumper car ride at Great America. The Court of Appeals held that the doctrine did not apply. It concluded that a commercial bumper car ride was not a sport and was therefore outside the scope of the defense. Well, the Supreme Court, I think, quite sensibly reversed 6-1. The whole point of the primary assumption of risk defense is that people intentionally and reasonably engage in risky behavior as a central part of many recreational activities, not just sports. If the courts were to impose the same standards on those activities as they impose in other contexts, much of the fun of the activity would be squeezed out. Low-speed collisions are essential to the bumper car ride experience. It's called, after all, bumper cars. And the jostling that occurs from those collisions is the very reason the ride is fun. Now, the plaintiff in this case suffered a very unusual injury. Apparently, because at the very moment of the front head-on collision, she had placed her hand on the dashboard of the bumper car at an angle where the head-on collision fractured the wrist. At least that's the allegation. Well, for the Supreme Court, that was still a type of injury within the reasonable scope of the bumper car recreational activity. And that's it for today's Kelso Report. Have a great day in the law.